Many property owners or high net worth individuals usually have an intention to transfer ownership of their properties to some of their beneficiaries during their lifetime. But because some of them don't know how to go about this, they usually delay. And in most cases, they don't end up transferring ownership of properties to their loved ones. And this usually creates a lot of challenges and disputes amongst their loved ones. That is why today I want to talk about a document called the deed of gift. When are you required to prepare a deed of gift in favor of your beneficiary? A deed of gift is a very simple and straightforward document. It's a document whereby an individual known as the donor, who ostensibly is the owner of the property, seeks to transfer ownership in the property permanently to another party called the donee. And once this document is signed regarding a property, what it means is that the ownership of that property has been permanently transferred to the donee. And the document takes effect immediately during the lifetime of the owner of the property. So I'll give you an example. Say Farouk owns a property and I want to transfer the property to one of my children. If I do a deed of gift between myself and my child, transferring ownership of the property to him, and I hand over the property to him and the document to him, automatically he becomes the owner of that property. And as the donor, I can't go back to say I want to cancel my gift or I want to retract my gift and take over that property. And that is why a deed of gift is very, very important. Indeed, there's a case at the Supreme Court where someone gave a property to an organization, and after some years, through a deed of gift, and after some years, he sought to cancel the gift. But the court said, no, haven't signed the deed of gift, identifying the property, identifying the donee, you are stopped and prevented from reselling from your gift or seeking to take back that property. So when we have properties, especially valuable properties like real estate, that want to transfer to a third party, to our beneficiary, it's not something you do orally. Because if somebody says they're giving you a property orally, it might be challenging for you in the future if the other beneficiaries challenge that gift. And another advantage of a deed of gift is that once a deed of gift is done, in respect of real estate, there's a requirement for that document to be registered at the lands registry. So once the document is registered, it becomes a root of title for your property, and you can then use that document to either transfer it to somebody else or sell the property. And if somebody issues a deed of gift to you in favor regarding one of their properties, what this means is that when the person dies, that property can no longer be included as part of their estate. So in estate planning or succession planning, deed of gift is not something that gets spoken about or utilized effectively regularly. So if you fall into the category of someone who owns a property and you intend to give your loved ones part of your property during your lifetime, then the best thing for you to do to show your love to them is to prepare your deed of gift and hand it over to them. And in preparing your deed of gift, there are some elements that must be taken into consideration. You must have legal capacity. You must be in the right frame of mind. You must identify the property clearly, such a manner that the property will be easily identifiable by any third party. And you must also hand over the property to the donee. And you must ensure that the deed of gift is witnessed, such that if a dispute arises in the future regarding the deed of gift, you can call the witness who witnessed the document, the signing of the document, to come and attest to the fact that you indeed issued the deed of gift. So deed of gift is a very brilliant and fantastic way of transferring our assets to our loved ones during our lifetime. And it doesn't have to be real estate alone. You can use it to transfer a vehicle, you can transfer any valuable asset, but there will be no consideration, meaning that you are not paying a purchase price. It's a simple gift. Once you pay consideration, it no longer becomes a deed of gift. Thank you very much.